Hey, Jenny Bradley here, owner of Triangle Smart Divorce in Cary, North Carolina. In today's video, I'm going to answer a question that we hear a lot here at the firm, which is, when will my spouse be required to pay my attorney's fees? This is a question that comes up quite commonly, and it's an area of law we've handled hundreds of times here at Triangle Smart Divorce. I'm going to explain when your spouse might be, and notice I said might be, required to pay your attorney's fees. First of all, you should also know that your spouse could agree to pay your attorney's fees. And I know for some of you that sounds crazy, but it does happen. I serve as a mediator and I've seen this happen there. Our entire legal team has represented clients at mediation, and quite often attorney's fees are a hot issue during a mediation. We have advised our clients at times to pay attorney's fees, and we have strongly asked for the other side to pay our attorney's fees in other cases. So don't think that you have to go to court to get some of your attorney's fees paid. You could possibly reach an agreement. Okay, that being said, I'm going to focus the rest of this video on when a court might order your spouse or your ex-spouse to pay your attorney's fees. There's 3 areas of family law where attorney's fees are in play. Basically, you might be able to get some of your attorney's fees if you're the spouse getting alimony or child support. Also, you might be able to get attorney's fees in a custody case. And the third area for attorney's fees is when the court is punishing someone because they haven't done what they're supposed to do. We call those contempt or motion to compel cases. Now, some of you might be asking, what the heck is a contempt case or a motion to compel? Well, a motion to compel is basically when somebody is not complying with the document process, like not coming to their deposition, not producing documents, not answering written questions, and so on. So if you have to take them to court and the court order them to go to their deposition or to give up documents, then you can receive attorney's fees. And what's contempt? Contempt is when somebody is ordered to do something and they don't do it. You ask the court to hold them in contempt to get the person to comply with the order. So it makes sense here the court can order attorney's fees as part of the penalty for not complying. So let's talk about the amount of attorney's fees. The court has the authority to order your reasonable attorney's fees. And we lawyers, we love that word, right? Reasonable. What's that? It's in the eye of the beholder. And in this case, the judge is the beholder. The judges have to look at the services provided, the worth of those services, and the scope and complexity of the case, as well as the time, the skill, and the labor expended by the attorney, and then compare your attorney's rate to other comparable attorneys in the area. The judge can also look at whether or not the other side increased their attorney's fees by doing any sort of shenanigans, for lack of a better word. Essentially, they were trying to run up your fees just by wasting your attorney's time or by doing nonsensical things. And one more thing I want you to know. You have to get the solution from the court that you are seeking to be eligible for attorney's fees. In other words, you have to receive alimony to be eligible for recovery of your fees, or you have to get child support, or the other person has to be held in contempt and have the court find them delinquent on their documents, and so on. You don't just get attorney's fees for filing the case. You have to win, too. As you have figured out, this area of the law is a little confusing and not straightforward, and it's very fact-specific. If you have questions about whether your spouse might be required to pay your attorney's fees, give us a call. We'll be happy to talk to you about the underlying claims that you may have and whether or not it's possible your spouse could be ordered to pay your attorney's fees.